Hey everyone, welcome back. Last month, the Supreme Court ruled that the state of Alabama's congressional districts violate the Voting Rights Act by illegally diluting the voting power of African Americans. However, we just got the reply from the state of Alabama, and they said, yeah, we're not gonna do that. And they somehow managed to make the situation actively worse. Not only do they still only have a single majority minority district, but they actually managed to decrease the number of minority voters within that district from 55 to 50%, making it barely majority minority. However, it's not the first time that the state of Alabama has defied the Supreme Court when it comes to issues of race. If you've studied any history, you know about Governor George Wallace standing in the schoolhouse doors barring African American students from going to school, and how President Truman had to call in the Alabama National Guard to get the governor out of the doors and let these children go to school in accordance with Brown versus Board of Education. So, what I wanted to talk about today is how this case might move forward and what options the federal government might have to force the state of Alabama to comply with the Supreme Court's order. This case is currently set to go before the same three-judge panel that overruled Alabama's original congressional districts. And given the fact that this new map isn't all that different from the old map, the justices probably aren't going to change their ruling, and they're going to find that this new map also violates the Voting Rights Act. The only thing that might be different is what order goes along with this ruling. The court could, of course, order the state of Alabama to redraw the districts yet again, but given how brazenly the state of Alabama is defying the court's previous order, they might instead turn the issue over to a third-party expert and have them draw maps that are in compliance with the court's order. The court has asked both the plaintiff and defendant to provide a list of names of potential experts, and given the fact that a third-party expert really doesn't have any political interests, it's probably the best way for the court to guarantee that a fair map is produced in accordance with the court's ruling. However, regardless of the outcome in the lower courts, the state of Alabama can always appeal the new map to the Supreme Court. And the hope here is that the Supreme Court will overturn Section 2 of the Voting Rights Act, which would then pave the way for legal racial gerrymandering. Now, gerrymandering by itself is terrible because voters should pick their politicians, not the other way around. But when you combine gerrymandering with racism, it's just completely opposed to the principles of representative government. So that's probably not going to help the state of Alabama's case. Additionally, Justice John Roberts has shown that he is very sensitive to any criticism of the Supreme Court, so given the fact that the state of Alabama is openly defying his orders, he's probably not going to be too impressed by their new case, and he's probably going to rule the exact same way he did in the last one. Additionally, again, given the fact that they really haven't changed the map very much, and the changes they did make negatively impact the voting power of African Americans, Justice Kavanaugh probably isn't going to change his position either, so we're probably still going to have the 5-4 majority that struck down Alabama's last set of maps. Now, if the courts remain consistent with their rulings and overturn this new map as well, the state of Alabama is left with two options. It can either concede defeat and have two majority-minority districts, or it can continue to defy the court's orders. If it does that, what kind of recourse is available to enforce the orders of both the lower and the Supreme Court? Well, the first option is contempt of court charges. All of the people who are responsible for drawing the maps and passing them into law and then implementing those maps in elections are violating an order from the courts, so they are in contempt. And that charge can contain both fines and jail time, and the list of defendants would probably be very long. Would include any Republican state legislator who voted for the new maps. It could include the state governor who signed the maps, Secretary of State, and other election officials within his office that are implementing that map. And the list goes on. It could be a really expansive case that could take out a lot of Republican members of the Alabama state government. And that, of course, would be quite the prosecution to run. I don't imagine that being a smooth ride. However, contempt of court charges aren't going to guarantee that the court's orders are implemented. And to get an idea of how the federal government might actually enforce the court's rulings, we can actually look at Alabama's state history in the wake of the Brown versus Board of Education decision. Then Governor George Wallace was none too happy about integration, and he physically barred the doors of an Alabama school in order to prevent African American students from attending. And President Truman decided that he would enforce the court's decision by federalizing the Alabama National Guard to help encourage the governor to get out of the way, both metaphorically and literally. And that's probably what would have to happen in this case if the state of Alabama refused to comply with the court's orders regarding its congressional districts. The federal government would have to step in and run all of the federal elections in Georgia, which would be the House of Representatives, the Senate, and the presidential election. Now, you can imagine that that might be just a little bit politically divisive and could easily feed into a number of conspiratorial narratives, such as the stolen election nonsense that we got in 2020. And there would be a lot of Republican politicians who would love to exploit that narrative in order to psych up their base. So hopefully it doesn't end up coming to that, but I honestly don't see another way for the federal government to actually force compliance with a court order without stepping in and taking over the elections there. And for those of you who say, wait, the elections clause says that states run elections. It does say that. However, it says that they must run them in compliance with laws and regulations passed by Congress. The Voting Rights Act is a law passed by Congress, so if a state is not abiding by that law, the federal government has the right to come in and enforce that law and ensure elections are being conducted in compliance with both that law and the rulings of lower courts, and especially the Supreme Court. Now, I hope that things never get that far, but we'll have to wait and see what happens. Honestly, I was pretty surprised with how brazenly the state of Alabama defied the Supreme Court's order, so who knows what'll happen if they lose again. But regardless of how this turns out, the one takeaway that I'm definitely seeing in all of this is that if the Republican Party has to resort to such an extreme form of gerrymandering in a state like Alabama, that cannot be a good sign for the future prospects of the GOP. Think about it.